yesterday too. You gotta scan that in too. Okay. And then, do you have the sheets for me? From the yellow.
Mm-hmm.
The yellow, his yellow sheets.
Yes.
Isn't there a fourth one?
There are more.
No, there's one on your, I bet on your.
Might be still in
Yeah.
there. Hey.
Thank you. All right, it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please.
Good afternoon, Judge Sue Opper, Leslie Daisy, and Zach Wichow appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security sesquique trust action which you are a real party and interest to as sui juris and propria persona. This is a military admiralty tribunal in maritime law under Title 4 of the United States Code Section 1, which you can see, which states placing of fringe on the national flag is within discretion of president acting as Commander-in-Chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, which has yet to be proven on the record.
These. No, where is?
May I receive those original copies time-stamped?
Okay. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept for value in return for value this document, and Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all
I did-
respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's gonna put it like right here, and then you want me standing at this table during
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what
as
yeah, I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually gonna be shown?
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument, so.
I'm making a request, the same request. May I be able to put up
Well, I guess it
exhibits?
depends on what it is, sir. So I'm not gonna take up any more time because what I intend to do is, once the state goes through its closing. I may take just a short comfort break depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that
That's
was filed.
not specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All
With
my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir, so I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks, you
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't say
matter
anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to you.
So they can't even know that I got a shock device on my ankles?
They absolutely do not need to know that.
Why
so it's
not?
not relevant to the determinations of guilt or innocence in this
It's
case.
the truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it
your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
no,
though.
Let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which
you're-
I preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460,
I'm
which will be
I'm
read
going
to the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
I'm not-
before they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started. I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or, I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty. All of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. I am
not
not
allowed to
required
make
to
the
give you
record at
that
all, Your
opportunity,
Honor?
sir.
I'm not allowed to make the record at all? As I just let you did, because some of the issues has been... Some of the issues has been...
You have told me what you want to do. I've told you you can't. I've addressed the request.
Some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that that's that is lawful for you to do what you've been doing as
Mr.
far
Brooks,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make
Honor,
an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will
I'm
have
going
an
to
opportunity,
inform,
if
I'm going
convicted,
to inform the
raise
jury.
every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution. You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so
its
we're not talking
reasoning
about
is
the right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm
ruling
not going
on.
to delay
You
any
already
further
made a
the
ruling
closing
on.
arguments
But
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request
with all due
once
respect,
the state.
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks,
So we're talking about now. We're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are
can't
at the stage
tell
of
me
the
I can't.
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
I'm not attempting
the court's
to delay
intention
anything.
of moving
I let
forward
you,
with
Your
the
Honor.
closing argument.
I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective, that is in an
how am I
attempt
being
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am
So
I being
you are
in
put
dishonor?
on notice. I am done dealing
How
with
am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I not
going
preserved
to
my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made my
can hold me in
determination.
contempt by Illinois versus Allen. You can do that. You've stated that numerous times.
Mr. Brooks, I want you here for the closing arguments,
Apparently
but you
you
do
don't.
not
Apparently
want to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir,
or
and
I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say. But I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant,
Honor. This
they're
is a
not-
whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But
still
I need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held
when
in
this door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even.
coming
There's no
out.
lawful law to say that you
I'm
can even
advising
mute
you
me.
to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All rise.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here, however, the jury is still in the hallway. I'm gonna give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your
he
Honor,
agrees with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the
not,
way
I'm
that
not
you have
disrupting
through
the
the course
proceedings.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury.
asking
I'm informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you
follow
going to
the
answer
court's
questions as a public
requirement?
servant on why you're making up laws that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button.
can
It
go
never
back
said
to the
anything
jury
about a
room.
mute
Thank you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not?
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
You can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I
and
can
you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment.
I need it quiet in the courtroom, please. We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom, and during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. And she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point, so should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made, and if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign, and if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, 2 quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking her head, they've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust
Sure.
accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test,
Yes, could we please?
please. Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off the, all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good, thank you.
All right, with that, the jury is to be brought out.
Okay.
All rise for the jury, please. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And Madam Clerk, if you would please turn on the PowerPoint.
Yes. Oh, hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Doro. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa, whoa, whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charged in counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First-degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got some.
Count 4, Jane Kulik.
Thank
Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Doro instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The Extreme Dance Team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the Extreme Dance Team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the Extreme Dance Team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The Dancing Grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Alford, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Opera. Your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how
Opera.
can speculation be made to what was saw? If
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Opera.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Warner's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route, at any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's
Your objection,
intentional.
sir?
Mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opera.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we gonna mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted. It's overruled. You may continue, Attorney Opera.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and a hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when she saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but That's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen. That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt. Your objection, sir?
How can you tell the jury what they're supposed to think?
Proper argument, your objection's noted, it's overruled. You may continue.
I would argue that it's, I would say that it's improper, and I move
Mr.
for a
Brooks,
mistrial.
I made my ruling. I'm going to mute you if you don't follow the rules.
Exhibit
I move for a
1.
mistrial.
Exhibit 152. Clearly intentional conduct.
52.
Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Take this one. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there, and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. You heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
Your Honor, with all due respect, I would appreciate the quote-unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map, 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please. Go ahead.
Thank you. Before we continue with Mr. Brooks's closing arguments, I am going to take a short break. All rise for the jury, please.
Am I muted?
No.
The jury should know that they can nullify.
You are muted now. Thank you. We'll be in recess for about 10 minutes. The record should reflect that Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms, here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I will hope it proves subject matter jurisdiction on the record, too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document, as is not based in lawful law, and it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record should reflect the jury is coming out. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves to
Mr.
need
Brooks,
to
this
know.
is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury. Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkes case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court of
Allen.
Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how is that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are 2 examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able
that
to testify
ruling
to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And
arguments.
you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were
And-
brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you
not
are going
trying
to
to give.
let me ask you a
No, hold on.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
you
attention
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them
Sir,
merely to be informed.
You can
That's it.
call it informing, making them aware.
Yeah, they should be aware
you
of the
are not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's
because
not what I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions the law note on jury nullification 705. What that says, sir, is I'm not going to read it all. It's many, many pages. But the bottom line is it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when
wasn't-
I raised the issue,
if you
Your Honor,
think
let me
that
finish.
I'm not prepared to deal with an argue on jury
I
nullification,
didn't say
then you
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
You've
how did
interrupted me
I have? Why did I
repeatedly.
have to sit here for that? Where I could have just went to my cell and had it delivered. We had this
Mr.
at the end
Brooks.
of last night before you called recess.
I'm not going to debate
we had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we go with
can
this.
roll your eyes
Here
at
we-
me
because
all
it's,
you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then
I
I
will
said,
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
does-
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No,
because the more
you can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, Your Honor, with all due respect, I'll let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I am squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the rule for your closing argument.
Vehemently object to that.
Your objection is noted for the record. But
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your Honor,
a court of
because-
appeals, not this court.
No, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law and
address it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also, you're
please
also,
let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor. That's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why
nullification.
can't they be informed of their power?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've outlined that to
motion
date.
for a
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, But I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request a legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury
based
is
on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Move to strike misstatement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year. For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun. Over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves, How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself. I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in
Improper
fact-
argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection,
for those
facts not in
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's
completely
information,
inaccurate,
it's
Your Honor.
information.
Objection. Hold on.
Strike.
Go ahead.
Move to strike statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played Exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. You've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard it's not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. Haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that message, well, not message, but that writing when we're in our vehicles and we got that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. Everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. was right. Make the right decision. It's hard to think about my younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day from my youngest daughter, and she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter. She said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet. The rest of that sentence said, "That's not the dad I know." Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be. So before I close my statements, I just want to say, open your hearts. go inside yourself when making this decision. Have no fear. Pray and do what you know is right. What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Had no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. And it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it.
Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute, so please stand. All right, have a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, the Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me. Count 4. Count 4. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 4 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 5. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 5 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 6. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 6 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 7. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 7 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 8. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 8 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 9. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 9 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 10. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 10 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 11. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 11 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 12. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 12 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 13. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 13 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 14. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 14 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 15. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 15 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 16. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 16 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 17, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 17 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 18, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 18 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 19, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 19 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 19 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 20, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 20 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 20 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 21, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 21 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 21 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 22, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 22 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 22 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 23, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 23 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 23 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 24, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 24 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 24 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 25, one reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 25 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 25 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 26, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 26 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 27. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 27 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 27 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 28. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 28 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 28 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 29, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 29 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 29 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 30. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 30 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 30 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 31. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 31 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 31 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 32. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 33 of the information. That should be 32. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 32 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? We're going to have you take a short stand break while I confer with Madam Clerk. This is 32. So, I'm sure you have all the verdict forms, right, but this will need to be corrected. So I need a 33.
Okay, well, you could read one twice and then I'll make another one.
Yeah.
It starts with page 88. Got it. When you're ready, have a seat. Count 33. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 33 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 34. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 34 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 34 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 35. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 35 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 35 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 36. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 36 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 36 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 37. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 37 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 37 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 38. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 38 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 38 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 39. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 39 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 39 of the information. If you find the defendant guilty of first degree recklessly endangering safety, Answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 40. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 40 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 40 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 41. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 41 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 42. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 42 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 43. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 43 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 44. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 41 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 45. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 45 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 46. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 46 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 47. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 47 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 48. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 48 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 49. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 49 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 50. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 50 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 51. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 51 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 52. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 52 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 53. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 53 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 54. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 54 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 55. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? I think I'll give my jurors one more stand break before I conclude. So please stand, and anyone else in the courtroom, please. yours, if you want these too, for now. That's more.
Oh, yeah, I did, redid all those.
Oh, did it? Yeah. All right, thank you. Have a seat. Count 56. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 56 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 57. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 58. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 58 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 59. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 59 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 60. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 60 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 61. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 61 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 62. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 62 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 63. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 63 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 63 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 64. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 64 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 64 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 65. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 65 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 65 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 66 of the information. I'll just repeat count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 66 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 67. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 67 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 67 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 68. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Virginia Sorensen? Count 69. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 69 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Leanna Owen? Count 70. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 70 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Tamara Durand? Count 71. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 71 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jane Kulik? Count 72. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 72 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Wilhelm Hospital? Count 73. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 73 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jackson Sparks? Count 74. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 74 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information. Count 75. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 75 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged, in count 75 of the information. Count 76. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of battery as charged in count 76 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration.
Wait, hold on.
Yeah, let's.
I have a lot of stuff up here.
A little bit personal.
There we go. I counted and recounted 15. So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I am pulling out is 10. The second number I am pulling out is 30. And the third number I am pulling out is 1. I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure. And I just confirmed that the other 12 numbers were in there. I'll put those back in and then we'll make a record of that. All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration, and I'll go ahead and do it. Oh, thank you. Clerk of Court Taz, why don't you join them just in case you're needed? All right, would you all please raise your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? All right, and then Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with. We do have all of the verdict forms, if I want to give that to Jen.
That should have all the new ones in them. It does.
All right, and here are the jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations. We'll make a record of what she did previously. But
Yeah, I'm gonna need all of them, and then I'll
yeah,
tape
no, I
them
know.
down and all
But
that
those are
business.
the.
Yeah.
Is that closed?
No,
All right, thank you. You may be seated.
just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room, and will only be called upon if needed, of course, after consultation with the parties. As far as how late, I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment from the state?
Thank you, Judge.
Anything from you, sir?
Yep. So essentially, I would have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my pod. We only get 2 shower days a week.
So here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for reckless. 61 injured parties did not testify. So how does that work? How essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming. and I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today, so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See, I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt you.
Thank you, I appreciate that. I would like the parties back in about a half an hour. Thank you, unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I get to go?